everyone. Welcome to Crime in Court. This is the 1996 Menendez brothers retrial. We're reading through the transcript. California versus Erik and Lyle Menendez on trial for the second time for the homicides of their parents, Kitty and Jose. They've always admitted to doing it, but the reason why has always been contested, I guess. The brothers claim that they have been maltreated their whole lives, and the evidence corroborates that. Um, but the defense or the state obviously is saying that they are these money hungry, spoiled brats that just did it for the money. So obviously, there's really been not a lot of evidence regarding that. So, and more evidence supporting the brothers. You know where I stand on this channel. I am in favor of the release of the brothers, and they may get a release. Actually, they've been resentenced from life without the possibility of parole to 50 years, and they have parole. Basically, that makes them eligible for parole immediately. They have a parole hearing August 21st and 22nd, and they delayed that. So, just in case you were wondering, it was supposed to be tomorrow, actually, the 13th of June, but they delayed it to prepare, to give themselves a little bit more time to prepare for their parole hearing. Because if you don't get it the first time, then you got to wait a long time for the next one. Um, it's better to go in more prepared, I guess. So let's get started with our transcript read today. We are going to get started with some argument from the lawyers talking about Dr. McCarthy. Dr. Roger McCarthy is the biomechanical engineer who he's from failure analysis, and he created all these diagrams. He did not testify in trial one. So he created all these diagrams basically depicting the scene, making it like as gruesome and horrific as possible, of course. And as you know by reading through the transcript for Dr. Lawrence, Dr. Robert Lawrence, he was the uh, pathologist who he also did not testify in the first trial. He reviewed the ME who actually did the autopsies. He reviewed their notes and reports and all that. And then he is the one testifying in this trial, or he did testify already. But he testified in great length about those diagrams and stating that the diagrams aren't exact. The little dolls that he did are not exact. So the only way to be truly exact is to look at the images of the autopsies. The crime scene photos and the autopsy photos are the only way to be precise about where the location of the wounds were. So we already know going forward into Dr. McCarthy's testimony today that he made these diagrams, and we already know that Dr. Lawrence has basically discredited them. So that's going to be interesting. And he also didn't really want anything to do with them. If you remember, he's like, I didn't make these. I don't know where these are from. So that was an interesting take on that, too. So let's get started here. Please hit the like button, and we're going to get started with, like I said, some argument between the attorneys about Dr. McCarthy's testimony, and then we will get to Dr. McCarthy's testimony. So here we go. The court says, without the jury, the lawyers and defendants are here. Something you wanted to discuss? Ms. Abramson says, well, Your Honor, as we indicated even yesterday, we believe that we should have a brief hearing under 402 concerning the scope of, she says Mr. They go back and forth between Mr. and Dr. I think he's a doctor. Um, we'll find out. Okay, so Mr. McCarthy's testimony and specific illustrations that we understand he intends to use. Hold on, why is my screen flickering? All right, I think that's better. She says, just as a point of information for the court, I had inquired in open court several days ago as to what exhibits, what demonstrative evidence was the word I used, demonstrative evidence, the people intended to use with Dr. McCarthy, and we were informed at that time that we would be using his computer. We had previously been told he wouldn't to project the images, and then there would be a hard copy, was how it was described for the jury, just like they had been using, they said. And as the court knows, because you've seen them, the hard copies have we have been using are 8 by 11 printouts provided to us. Returning from recess this afternoon, I saw those stacks of large charts, which each one contains one of the 24 illustrations. I'll just take this is 7A because it's just the closest one, Judge, to so the court can see the size of the illustrations the people now intend to use. So all those little diagrams, they blew them up. This is all too typical in this case that we ask what the people are going to use and they mislead us and they bring something else in. And I object at this point to the people using those enlargements. I scaled my demonstrative exhibits to what I believed was going to be the people's scale for the demonstrative exhibits and was, as you recall, sandbagged. That's an aside. Now, the heart of the matter under 402 is this. The court had previously indicated that since Dr. McCarthy does not have any medical training, he could not offer conclusions based on medical knowledge unless a foundation has been laid for his conclusions through the testimony of a qualified expert. So, that's important to note. He is a doctor, perhaps. He has a PhD in biomechanical engineering, but he is not a medical doctor, so he cannot opine on medical conclusions. So that's an important thing to take note of. Now, we have gone through 2.5 days of Dr. Lawrence's testimony, and it is our contention that, with respect to some, though not all, of Mr. McCarthy's illustrations, there is no foundation in the medical evidence to support them. He didn't even want anything to do with them, Dr. Lawrence, and he said he didn't approve them, he wasn't sent them, he didn't, he has nothing to do with them. So, yeah, this makes a lot of sense to exclude them because he did not say that they have any medical support, any evidentiary support medically. Because he always said go back to the pictures. The pictures are the best way to determine the locations and things. So, and most specifically, his whole shot sequence, number one, is not supported by medical evidence, and with respect to part of that sequence, depending on which moment he was testifying, Dr. Lawrence either disagreed outright with the wound as depicted or indicated he couldn't tell. Well, Dr. McCarthy has no medical training, so he can't tell either. And it's our position that only with respect to those wounds where there has been proven thus far uncontroverted or actual medical opinion that the illustrations be supported by medical testimony should Dr. McCarthy be permitted to show the illustrations. Yep, she just said it that they need to have evidentiary support, medical evidentiary support by an expert. So that is not true for this shot one, and so we object to any depiction of that sequence. And I believe that it is not true unamended to his shot four, which is supposedly the shot to the right side of Mrs. Menendez's face, the upper shot, the one in the eye orbit, that has to be corrected before he should be permitted to testify about that shot. He should not be permitted to testify about or to illustrate shot 10A and B because that is not consistent with the actual injuries per the medical opinion. That's important. That is necessary. And those, I believe, are the ones that we're objecting to in total, I think. Toto? In toto. We're objecting to it in toto. I think she means, I don't know. Anyways, in addition, we would object to the showing of the projection screen. We were told, by the way, it would be a television monitor, the same monitor that had been used previously to show the crime scene video. And now it's being projected on the board and not the television monitor. We would object to the projection of any autopsy photographs taken at the time of the autopsy, because Dr. McCarthy is not qualified to render medical opinions based on those photographs. That photograph that were those photographs that were relied upon by Dr. Lawrence and before the jury, that if Dr. McCarthy, in reliance upon Dr. Lawrence, wants to point to something that's already an exhibit, that's fine, but we object to him projecting and offering his own opinions about any of the coroner's photographs as beyond his area of expertise. And we ask, therefore, that his testimony be limited to those things for which an adequate foundation has been laid, and not allow any testimony based on medical opinions that he has. And by the same token, he testified during the 801 hearing that he has no training in reading x rays. So we object to him showing x rays or commenting on what's in the x rays as well. The court says, Mr. Gessler, anything else? Mr. Gessler says, for Lyle, so that was argument for Erik's side, and now Lyle has an objection as well. He says, I join in that objection, Your Honor, and also, as far as the ones that he is allowed to testify to, that is, the shots that he's allowed to testify to, that anything having to do with a medical basis being put to him as a hypothetical question based on the testimony of Dr. Lawrence and supported by it, rather than allowing Dr. McCarthy to give his own medical opinions in the guise of injury and exit wound or any of that type of thing. The court says, Mr. Khan. Mr. Khan says, yes. As far as the illustrations are concerned, I did not indicate to counsel that during the presentations with Dr. McCarthy, we were going to be using 8.5 by 11 in size. When counsel wanted to know whether there were any further changes that were made to the substance of the illustrations, and I informed her at the time that there were some changes made to the sizing of the furniture inside the room. And later, when there was one additional change, which was simply to the numbering in the upper left-hand corner, we also let counsel know about that so that counsel would be totally aware of the image that was going to be presented. We didn't indicate it was going to be an 8.5 by 11, and I don't think that counsel can complain about the size of the illustrations. They're simply what she has already been provided, except in larger form. As far as the one of as far as the use of the projection is concerned, this is the problem, letting counsel know well in advance exactly how we're going to make this presentation, because our plans concerning this presentation have changed frequently. Every single time we make a presentation to the court, that presentation was accurate based upon material that was available to us at the time, and our belief concerning the appropriateness of that particular form of presentation. It was only today that we decided that the best way to go is with the projection. The monitor is upstairs. It's just the cables just weren't hooking correctly. We have to go with what we have, and I don't see any harm in using the projector as opposed to using the large screen monitor. It's still the same image, so there's no prejudice there. Turning to the substance of the testimony of Dr. McCarthy, I think that an adequate foundation has been laid through the testimony of Dr. Lawrence. Oh, you think so? Because he didn't want anything to do with these diagrams. The issue before the court was not whether, as counsel would like to describe it, there is a medical basis for everything that Dr. McCarthy is going to testify to. Clearly, there doesn't have to be a medical basis for depicting the coffee table in the position where it is, any more so than there has to be a medical basis for depicting the position of Jose's right leg at the time that he was sitting on the sofa. The question is, to the extent at that time the opinion of Dr. McCarthy may rely upon medical foundation, has that medical foundation been shown, and that I think has now adequately been shown through through the testimony of Dr. Lawrence, who was provided information concerning all of the essentials on which Dr. McCarthy will be testifying. That is, he has testified to the cause of death. He has testified to each and every single wound that Dr. McCarthy will be referring to. He has testified in regard to every single photograph that Dr. McCarthy will be relying upon. He has testified in regard to every x-ray that Dr. McCarthy will be relying upon. He just repeated that. He has testified to the whether or not every single of those wounds would have been immediately fatal. He has testified to whether each of those wounds was postmortem or antemortem or perimortem. He has testified in regard to the association of various wounds. He has even testified in regards to sequencing of those wounds. I think he said multiple times that he was not sure of the sequence or whether it was antemortem, postmortem, or what's the other? Perimortem on some of the wounds. So he said that multiple times. So he has provided a total foundation for everything that Dr. McCarthy will be testifying to, and no further foundation should be required at this time. Turning to the specific shots that counsel is now referring to, as far as shot 1 is concerned, Dr. Lawrence said that his opinion is that although it could possibly have been two separate shots that caused the wound to the right arm of Jose Menendez, it is also his opinion that the wound to the right arm of Jose Menendez is also consistent with a single shot, and he made that very clear in his testimony. As far as shot 4 is concerned, he said there is some slight difference of opinion concerning the precise angle at which that particular shot struck the right eye area of Kitty Menendez, but he indicated that it's a very slight deviation, and in fact, he illustrated in regard to on one of the diagrams that has already been marked just what that deviation consisted of. And we can see from looking at it that it simply is a very slight angle. So I don't think that the very slight angle difference is sufficient for counsel to argue that the testimony of Dr. McCarthy isn't admissible in regard to that shot or to any other shot for that matter. And finally, with regards to the x-rays that he will be relying upon, once again, regardless of the training in x-rays, we have sufficient foundation for the x-rays that has been presented to the jury. Counsel indicated that there would be an objection to the x-rays that were taken by the coroner's office and which are currently before the jury. That was part of the stipulation that we entered into, and Dr. McCarthy, during the course of his testimony, will be referring to those very same x-rays, counting the pellets, which anyone is qualified to do by looking at the red, round, white-shaped objects in X-rays, as Dr. Lawrence has already laid a foundation for, and he will be indicating which of those X-rays he relied upon and why. Ms. Abramson says, Your Honor, just with respect to shot 1, Mr. Khan left out part of it, and that is Dr. Lawrence clearly said shot 1 is inaccurate, not only because he does not believe, although he won't rule it out as impossible, that both wounds in Mr. Menendez's inner right arm are caused by the same shot, but because he also originally indicated, and I don't think he's ever backed off of it, that there's correspondence only between the left elbow shot to Mr. Menendez and the left breast shot to Mrs. Menendez. In addition, what's most notably missing from this illustration is that he does believe, as the coroner believed, as the photographs show, that the wounds to Mrs. Menendez's left forearm were caused by the same shot that penetrated the left breast, and the illustration does not show that. Moreover, I think it's obvious, and Dr. Lawrence made it clear that the trajectory shown in shot 1 is wrong with respect to the medical evidence concerning the location of the wound to Mr. Menendez's upper right arm. So, there are many reasons why he was clear that he does not and cannot support what is drawn in illustration 1A and 1B from the medical evidence. And Dr. McCarthy is not qualified to decide whether or not the left forearm is associated with the breast. He is not qualified to say whether or not a shot passed through the inner part of Mr. Menendez's upper arm and exited into the left breast of Mrs. Menendez. He does not have the medical qualifications to say or do that. Dr. Lawrence did not provide the foundation for this specific sequence of shots. With respect to 4B, all we're saying is redraw the perspective line to fit with what Dr. Lawrence said. But we think that presenting this to the jury, particularly in this enormous form under 352, is confusing the issues, misleading the jury, giving them unsupported information, false information, and doing it in a very graphic visual form, and that's why we object. The court says, as far as the charts or diagrams, they were previously shown to counsel in their smaller version. There was really no representation by the prosecution that those smaller versions would be the ones that would be used, At least no representations made in my hearing. To the contrary, I had assumed that the prosecution was going to use larger versions just from practicalities. Okay, how can you assume that? You can't just assume that they're going to do that. The small versions are very difficult to see. I had assumed that larger versions would be used, so I don't see any sandbagging here. I think it was predictable they would bring in something that would be more suitable to the purchase of demonstration evidence in a trial. I don't think you can just count on, and they need to show it to defense counsel. They can't just do it and be like, "Oh, here's the day of testimony. This is what we're using." That's not how evidence and uh, pieces of evidence that you're going to put into trial. That's not how it's supposed to work. But here we are again with the state trying to pull some shenanigans of their evidence and who they're calling for witnesses and making sure that the defense can't be prepared for whatever it is that they're doing. As far as the use of the type of display here, the defense is on notice and it has already been discussed and it's all on the record as far as the position of the parties in regard to the type of display that would be used. Whether it's on a television screen or projected on to some other screen or device, I think is a distinction without a difference, and I think the manner of presentation here is well within the scope of the notice given to the defense and to the court. As far as the objections to the underpinnings, or at least the medical underpinnings of the proposed testimony of Dr. McCarthy, I have listened to the evidence and watched as it was presented and evaluated, looked at it, at the proposed diagrams that we have seen earlier in the hearing involving Dr. McCarthy, bearing in mind that the assumed facts and questions asked of an expert need not be entirely undisputed, so long as there is some evidence to support them. The court is satisfied, and there is sufficient evidence, go figure, here to justify, excuse me, got a cough. Sorry, dry throat. He says that there is sufficient evidence here to justify the presentation as outlined by the prosecution. It certainly is an area of cross examination and impeachment of Dr. McCarthy as to the underpinnings of his opinions. But I don't find that if his testimony follows the pattern that was presented to me in the hearing that we concluded after the jury was selected and before the opening statements, the hearing at which defense initially objected to the testimony and then withdrew the objection. I don't find that such assumptions made by Dr. McCarthy would be misleading to the jury, but certainly would be subject to cross examination and pointing out any frailties or defects in those assumptions. That ultimately is a question for the jury to resolve as to the weight to be given his testimony. So he's going to let him just testify to all his medical opinions, even though he's a biomechanical engineer, not a medical doctor. But I don't find that the questions that would be proposed to Dr. McCarthy would be misleading based upon the testimony presented by Dr. Lawrence. Therefore, the objections are overruled. Mr. Gessler says, Your Honor, I have one further objection then. Given that is to clarify, that is, that Dr. McCarthy not be allowed to answer the district attorney's question like, Dr. McCarthy, do you have an opinion as to what is an entrance wound or an exit wound, or what is an antemortem wound or a perimortem wound, postmortem wound? Because that is beyond his expertise. What he can do is say, Dr. McCarthy, assuming that based on something that Dr. Lawrence has said, but I don't think he can ask Dr. McCarthy for Dr. McCarthy's personal opinion in the guise of buttressing Dr. Lawrence's opinion, since Dr. McCarthy is not equipped to give such an opinion directly or indirectly. The court says, I don't assume that the prosecution is going to do that. Did you intend to do that? Mr. Khan says, No, I was not planning on doing that. The court says, All right. Obviously, Dr. McCarthy is not a medical doctor, and his testimony must be based upon that of other experts who are expert in the field of forensic pathology, such as Dr. Lawrence, and any questions that go beyond that will be subject to proper objection. Mr. Gessler says, I would also ask, Your Honor, that Dr. McCarthy be cautioned to answer in that vein. In other words, not to volunteer opinions as though they are his own, when actually they have to be based on that of somebody else. The court says, well, it should be stated the basis of any of his opinions, and that certainly will be part of that. Ms. Abramson says, one other thing, Your Honor. Given the nature of Dr. McCarthy's report, which the court has seen, we would object and would rather not have to do it repeatedly in front of the jury. So we object now to his being asked what was in the mind of the shooters, what was in the mind of the victims. The court says, well, did the prosecution intend to do that? And Mr. Khan says, I was not going to ask that question, Your Honor. Ms. Abramson says, okay, that would totally be speculative. The court says, all right, anything else now? Mr. Gessler says, that would include aiming, Your Honor, which I think is the way that this was put. And it's beyond his discipline, beyond anyone's ken where something was aimed. Court says, did you intend to use the phrase aiming? Mr. Khan says, no, I was not intending to. Miss Abramson says, could the witness be admonished not to volunteer it? The court says, if it's not asked, I'm sure he's not going to say it. Really? You don't know that. Anything else before we proceed? Ms. Abramson says, no, Your Honor. The court says, let's get the jury out, please. The jury has now entered the courtroom and the following proceedings were held. The court says, okay, the jury is back and will resume with the trial. People may call their next witness. Mr. Khan says, yes, people call Dr. Roger McCarthy. Dr. Roger Lee McCarthy was called and sworn in. The clerk does it. He says his name, all that good stuff. Now we are on direct examination. Oops. Mr. Khan says, sir, could you tell us what your occupation is? I'm an engineer. And what is the name of the firm that you work for? Failure Analysis Associates Incorporated. Remember, they're the ones that did all of the diagrams that we were referring to in Dr. Lawrence's testimony. So where is Failure Analysis Associates located? We're headquartered in Menlo Park, California. And what is your position in that firm? I'm the Chief Executive Officer. Can you tell us how large this firm is? Oh, currently we have 400 some odd people, probably 300 some odd, 300-ish professionals, of which 90 some odd hold doctorates in the various fields of specialty science and engineering. And how many offices does your firm consist of? Failure Analysis is the largest operating unit of the Failure Group. Failure Group has 13 offices. Are they located in this country? No, we have an office in Dusseldorf, Germany, an office in Gdansk, Poland. I have no idea if I'm saying that right. Now, you mentioned failure analysis and you mentioned failure group. Can you tell us what the distinction is between the two? Yes, we formed the failure group in 1990 to take basically failure analysis public. It is a public traded vehicle on the NASDAQ exchange for the failure group. We're traded under the symbol FAIL. That's probably not the symbol you want. FAIL. You don't want your company to fail. I wonder if they're still in business. And I really wanted to look this up, so hold on. Yeah, so they're still in business apparently, and um, they've teamed up with another company, it looks like, and I see they have an office now in Fort Wayne, Indiana. Um, Failure Analysis Services. Okay, here's their website. Yeah, so they're still around. Um, but I just I think a NASDAQ symbol of fail is kind of a self-fulfilling prophecy. Anyways, all right, so Mr. Khan continues. You indicated that you are the Chief Executive Officer of Failure Analysis Associates. What is your position in regards to the Failure Group? I'm also the Chief Executive Officer of the Failure Group. And how long have you been the CEO of the Failure Analysis Associates? Since 1982. And how long have you been the Chief Executive Officer of the Failure Group? Since 1990, when we formed the group. Now, can you tell us what failure analysis is? What is that firm and what does it do? I'm sorry, that totally reminded me. Totally reminded me of Kindergarten Cop. Who is your daddy and what does he do? Sorry, that was probably a really terrible accent, but what is the firm and what does it do? We believe uh, ourselves to be that was Kindergarten Cop, if I didn't say that. Kindergarten Cop, Arnold Schwarzenegger. We believe ourselves to be the largest engineering firm in the nation, engineering and scientific firm devoted to the analysis and prevention of failures of an engineering or scientific nature. Now, before I get into detailed questions concerning failure analysis and the work that your firm undertakes, let me talk a little bit about your own background. Can you tell us what degrees you have as part of your education as an engineer? Yes, I have a Bachelor of Science in Mechanical Engineering from the University of Michigan in Ann Arbor. I have a Science Master's in Mechanical Engineering from the Massachusetts Institute of Technology, Cambridge, Massachusetts. I also have the professional degree of Mechanical Engineering and a doctorate in Mechanical Engineering. The latter two graduate degrees were also from MIT. Can you tell us what the professional degree of mechanical engineering is? Yes, it's a degree offered at MIT for applied research. It requires all the coursework of the doctorate, but requires a separate thesis from the doctorate. MIT has a reputation for producing a theoretical thesis, so it's a separate degree that you must earn through an applied thesis. You actually have to build a design, some practical device. In addition to those 4 degrees in mechanical engineering, do you have a fifth degree? Yes. And what is that in? I have a Bachelor of Arts in Philosophy. Okay. Now, as part of your career as an engineer, have you received professional honors? Yes. And can you tell us what professional honors you have been awarded? I graduated summa cum laude from the University of Michigan, first of my class, the outstanding undergraduate mechanical engineer in 1972. I was selected as a National Science Foundation Fellow. Those are the academic honors. And you have also been appointed by the President of the United States to a scientific advisory position? Yes. Can you tell us what that position is? Yes, I was appointed by President Bush to the President's Commission on the National Medal of Science through the National Science Foundation. There are 10 people who select for the President of the United States from whom he is going to award the National Medal of Science in 6 different science areas, or at the President's discretion, up to 8 medals are awarded, but basically he awards annually. It was just done about 3 weeks ago. Medals in the areas of mathematics, physics, biology, and the National Medal of Science in the highest scientific award this nation can award to an individual, and the president awards them to the individuals that those of us on his commission select for him. That's kind of interesting. I mean, he's got some really good qualifications, I'm not gonna lie. So let's see what he's got to say about the diagrams and such, the crime scene here. So, next question. You are a member of the committee that advises the president as to who should receive those awards? Yes, there are 10 of us basically that represent the various areas of science and engineering, and we cull through the several thousand nominations annually for these 6 to 8 medals that he will award. You said that you were appointed to that position by President Bush. Did you continue in that position or were you reappointed to that position? I continued in that position and was on 2 years of committee selection for President Clinton as well. Now, have you also been appointed by the Secretary of the Army to a position? Yes. And what position is that? I am a member of the Army Science Board. Can you tell us what the Army Science Board is? Yes, it's a group of 100 scientists and engineers that the Secretary of the Army appoints to advise the Army on issues of science and technology relevant to the Army's mission. And in that capacity, are you heading a particular study for United States Army? Yes. What study is that? I'm currently chairing the study committee on the decisive 21st century infantry weapon. That is, the rifle for the 21st century for our soldiers to carry. So you are chairing a committee that will determine the nature of the infantry weapon that the U.S. Army will use in the 21st century? Well, the 21st century, like, that's so crazy and far away. We're in 96, so, this is thinking ahead to Y2K. Well, we're at a level where we won't determine the precise configuration of the weapon, but add our input into the description and type and configuration of the weapon, what type of ordnance to shoot, given different strategies for projectiles, things of that nature. Now, do you have a background in firearms? Yes, I was an ordnance officer in the Army. And what is an ordnance officer? Ordnance is the branch of military service that's concerned with the Army's weapons system, their development, employment, maintenance, training, and some questions related to the doctrine of their use. And when were you an ordnance officer for the Army? I was commissioned in 1972 and did my officer basic branch school in 1973. And since then, have you developed some expertise in the use and operation of firearms? Yes, I'm actively interested in firearms. I actually have a range in my house. What type of range? A 50-yard range. I can stop up to a 50 caliber. And do you own weapons that you use in your range? Several hundred. And do you have experience firing a wide variety of weapons? Yes, of course. An ordnance officer is trained but the entire Army inventory, starting with a 45 caliber pistol and ending with the 155 howitzer. But over the years, I've fired most every assault weapon that's used in the world today. Because I have no, she's the clerk making mistakes again. Because I have copies of them and various other configuration of experimental weapons. Have you also had any experience doing ballistics reconstruction? Yes, in the occasional case where there are ballistics questions, I will get involved. I guess there are ballistics that are related to bullets, then, of course, large numbers of fires and explosions, particularly in explosions, produce projectiles, not just bullets, but they ballistically injure people and cause damage and also leave evidence behind in terms of what happened in any explosion. And have you qualified and testified as an expert in court before? Yes. On how many occasions and what courts have you qualified and testified? Ms. Abramson says, I'm going to object unless it's in the field that's involved here. The court says, overruled. The witness says, I would estimate ballpark 100 times in state and federal court through the nation. Mr. Khan said, how many? 100. Mr. Khan says, let's get back to failure analysis for a little bit. You said, yeah, but how many times did he actually testify in shotgun blasts, in multiple wounds with shotgun blasts? There's more questions you need to ask about this witness, which I'm sure the defense will get into. But yes, okay, he may have testified 100 times, but what were those things he testified about? What was he an expert in? It might not have been ballistics. So there's more to be asked about that. Mr. Khan goes on and says, let's get back to failure analysis for a little bit. You said that failure analysis is involved in the analysis and cause and origin determination of failures. Is that correct? Yes. And what type of failures are you referring to? Just about the range of most types of major disasters and incident you hear about. We're assisting the United States Attorney in the reconstruction of the Oklahoma City bombing. Wow, so that was way back. It was more recently when that happened. What year was that? Obviously, it was before 96. So we're assisting Boeing in the event, I thought it was the 94, 95 maybe. We're assisting Boeing in the investigation of the Pittsburgh crash. We did the accident reconstruction on the Exxon Valdez for Exxon. I was the first investigator on the scene of the Hyatt walkway collapse. When the rocket fuel plant exploded near Las Vegas in Henderson, Nevada, we investigated that for the plant owner, Pepcon. Here in Los Angeles, we've investigated the collisions that have occurred of boats in and out of the harbor. When the large waste treatment pipe collapsed down in San Diego, we investigated that for the city of San Diego. When those Malathion, one of those helicopters, however you say that, I have no idea, collided with some high tension wires, we investigated that for the state attorney general. Now, when you say that you investigate these major incidents or accidents, what specifically do you do concerning these accidents or incidents? Basically, collect, analyze the available and remaining physical evidence to determine what happened. Basically, that's our job. People want to understand what happened in these particular incidents, first and foremost, to strive to be sure that such things don't happen again. And to do that competently and effectively, you have to understand that what were the change of events. What you have to understand what were the change of events, what elements brought about the undesired release of energy. That's basically what we define as a failure. Any undesired release of energy that causes injury or loss. Okay. Um, okay, and would that undesired release of energy include both accidents and incidents as you defined those terms? Yes, I mean, clearly the Oklahoma City bombing was a very undesired release of energy and caused massive loss of life. And a plane crash is exactly that. There's a tremendous amount of energy in a flying aircraft. Can you give us an example of the non accidental incident that you would investigate as part of your work that your firm performs? Oh, we do the occasional shooting by a law enforcement agency. I helped the production company that produced the movie The Crow, where Brandon Lee was killed, figure out what happened to Brandon Lee in that particular incident to bring about his death. Well, that's cool. I mean, I loved that movie growing up. So, that's interesting to me. I'm kind of liking this guy, even though I don't want to like him because he's testifying for the state, but he's got some really cool credentials. We investigated basically situations where there's an accident or incident where there's loss of life or great damage. Has your firm also undertaken work for NASA? Yes, over the years, NASA has been our biggest government client, basically because of the very demanding technology of the space shuttle. So he's NASA, not NASA. Again, once again, court reporter, you suck at this. There should be NASA, not NASA, with a U. All right. So, what type of services investigations did your firm perform relationship to the conduct to the work conducted by NASA? Well, starting in 1978, we probably delayed the shuttle's first launch by a year because of problems with the reliability of Rocketdyne's plane engine data. And then, after the first shuttle launched, there were the problems of the tiles falling off, and that was a big problem. We've never lost a shuttle to a heat tile falling off, but inappropriate loss of heat tiles could certainly cost a shuttle. We analyzed a shuttle to see if it needed an extra fuel tank for NASA. We decided it did. We analyzed a number of performance questions for NASA. We actually analyzed for NASA the safety of manufacturing the booster that exploded in the Challenger disaster the day of the Challenger disaster, and we assisted NASA in the investigation of the Challenger disaster. And we've assisted NASA in the redesign of the shuttle. So your firm also performed some work in regard to converting Russian nuclear power plants. Okay, that's awesome. Maybe I don't like this guy. He says his Polish office is primarily involved now in converting a Russian graphite design nuclear power plant installation that we located in Poland for natural gas use. We have been granted a license by the Polish government and are now in the process of collecting bids. Has anybody looked into this guy as like a Russian spy or something? Like, is this company allowed to be doing business in the United States if they're assisting? I don't know. Anyways, has your firm conducted crash tests on vehicles? Yes. And what have you done in that regard? I believe we are the largest independent vehicle crash tester in the nation. We have a test facility in Phoenix, Arizona. We have the fastest crash rail in the country. That is, we can crash cars faster than anybody else. But in addition, we do crashes daily. There are crashes where you see the anthropomorphic dummies and they're heavily instrumented and they have to be calibrated. And we also have a companion cadaver laboratory for very critical vehicle safety questions in our Philadelphia office. Obviously, you have to bring, if you will, sensitivity to cadaver testing questions, and you have to be testing questions of greater value to make that technique justified. Can you tell us who employs the services of failure analysis? Our clients, we think of them as we divide them into groups. First of all, governmental clients, and we do work for various branches of Department of Defense agencies like Department of Energy, EPA, whomever. We do work for various states and municipalities and governmental entities. On occasion, particularly when they have a particularly nasty problem, a bulk of our work is for Fortune 500 companies. Probably the bulk of that is concentrated in the Fortune top 50. We do a substantial amount of work for the major insurance companies of the world, Lloyd's of London, Tokio Marine, other large insurance entities. We also do work for individual attorneys and then finally individual citizens. The median job of our firm is $22,000. So occasionally a homeowner could be confronted with one part of his house that will settle a foot lower than another and want to know why. Now, did you also make a presentation for the American Bar Association in '92 in San Francisco? Yes. Did that presentation involve the use of firearms and ballistics in some way? Yes. Basically, we tried Harvey Oswald. Oh, so they did JFK. And the ABA set up two terms of trial experts on each side to one, to prosecute Lee Harvey Oswald, and one to defend him. That'd be interesting. And can you tell us what specific work you did in connection with that presentation? I was involved and led the defense team, and basically we set up the ballistics tests on the Curcano, whatever that is. That was a type of Italian carbine Lee Harvey Oswald used in the assassination. So it was the car, or sorry, not the car, the weapon. I acquired the Curcano that only differed in serial number by 1,000 from Lee Harvey Oswald, and I had a scope fitted by the same guy that fitted the Lee Harvey Oswald scope. He still works in Ojai, California. Interesting. Basically, we constructed skulls, did high-speed video of shots of skulls. I constructed specialized bullets of different types to illustrate different effects of the ballistics possibilities that occurred in that assassination. And of course, we did a lot of electronic image analysis and photo enhancement. We discovered in the Zapruder film, that's the movie you see of the actual assassination, that in one frame, Governor Connolly's lapel flipped forward and back in one frame, and it clearly times what has been called the magic bullet shot that was heretofore, since we were the first ones to look at the evidence, since PCs were invented, was not known. That timing was established through our work and a few other things. Can you tell us what you did more specifically with regard to that presentation concerning constructing skulls? Actually, one of the issues in the assassination, and of course, there were one or two shooters, And one key evidence is how President Kennedy's head responded to the fatal bullet in the Zapruder videotape. Most people have not seen those frames in the Zapruder tape. They are taken out of the publicly distributed version, but in the actual full unedited movie, his skull hits and explodes and it reacts to the bullet impact. And so the question raging debate has been, given the motion of the skull, what was the direction of impact and what kind of bullet hit him? And we shot the skull from behind with the Kirkano ammunition. The Kennedy Museum in Dallas kindly provided me ammunition from the actual lot of ammo for that gun that Lee Harvey Oswald's fatal bullet came from. So I had this 40-year-old ammunition of the authentic variety. And I also constructed basically what a professional assassin would use, which is called a glycerin bullet, and that's an explosive bullet. If any of you ever saw The Day of the Jackal, it illustrates what an explosive bullet does in that movie. Basically, I constructed those and we did comparisons of what would be the skull reaction with a standard military full metal jacketed bullet and the lead response, and what would be a side hit with an explosive bullet on the glycerin variety, and presented those to the jury in a mock trial. Did you actually use human skulls to conduct that experiment? Yes, human skulls that we divided and then filled with the animal brain matter. And we attached a skull that had the same mechanical properties and brain of the same mechanical properties to see how they would react to bullets from different directions. And I personally actually fired the weapons for all of these tests. Now, getting back once again to failure analysis and the type of work that your firm does overall, is there a common approach or theory that underlies the analysis and cause of determining the origin of failure and accidents? Ms. Abramson says, Your Honor, I'm going to object to this without a showing under 402 that it's relevant to what he's doing here. Court says, overruled. The witness says, I would say a common fact that is, you come to an accident scene and there's a collection of evidence and information contained in the scene in terms of the various materials there. There is only one. It is a simple fact. There's only one explanation of events that will explain all the evidence you see. Mr. Khan says, is there some approach or theory that you use to figure out what is that origin or cause for that particular accident or incident? Yes, and I guess I would be basically, it would be basically the theory that explains more of the evidence is more likely correct than a theory that explains less of the evidence. That's one way to explain. That was a confusing explanation. In other words, if any major disaster, typically you can construct little micro theories that would explain one piece of evidence. It wouldn't make any sense in the big picture, but you want to explain that incident or this particular part of the disaster, you can do that. But the real trick, you should have seen Leslie's face when he used the word trick. Holy crap. That's like this is a note that the transcriber should not have put in there. That should not be in the transcript. So she should have deleted that and she didn't. So there it is. But the real trick, oh, hold on one second. Sorry, I had to let the dog in. Also this is extremely very inappropriate that the court reporter would write that. But anyways, let's read it without that note. So, but the real trick is to explain the sequence, the whole series. It explains the multiple uses of evidence you see in the best way possible. Ultimately, the correct explanation is correct, and every detail will explain every piece of evidence. There will be no question. Seldom can you get there. That's really hard. Not always, but most of the time you don't get that. So what you end up with is getting as close as you can with the available evidence to explaining as much of the physical evidence as you see without contradicting, hopefully, any laws of physics or the first or second law of thermodynamics. What type of evidence do you look at to try to reconstruct and to determine what was the cause of origin of a particular accident or incident? Basically, everything that's there, recognizing that evidence has certain characters to it. That is, really heavy pieces of metal and wood and structural materials you can think of as very slow photographic film. They won't take an image very easily. It's very difficult to leave an imprint on them. More difficult than it is light pieces of sheet metal, cloth, fabric, paper, and unfortunately, in many cases, human tissue, which you get a lot of information from human tissue because it mechanically will break in known ways. It's also thermally sensitive, so you can see that gather on it as well as physical damage. So, human bodies in an accident scene very often provide very important pieces of information because they're essentially the surface of the body will take images, information about what happened that, if you know how to read them, will assist you in understanding what ultimately developed. Okay, the last two explanations he just gave, I think, were a bunch of BS. Didn't really say anything about anything, and he's kind of just bloviating and full of himself. But let's see. And I have an appreciation for this dude because of the Crow and the JFK files that he worked on, and I think he's done some cool things in his career. But the last couple explanations didn't get it. It didn't do it for me. Next question. Mr. Khan says, okay, and now in this particular case, did you undertake an assignment concerning the case before the court? Yes. And what did you do in this case? Basically, I attempted to the best of my ability to reconstruct the sequence of shots that resulted in the two homicides. He says the M word. Miss Abramson objects to the use of the M word, Your Honor. The witness says, I'm sorry. The court says, just use the phrase killing or shooting. So, like, those are any better? I don't know. Um, but yes, the M word is like, I'm saying the other word, so who cares? Murder is considered, that's the charge. So for them to say that word, it's kind of prejudicial. You shouldn't be using that. So they have to say other words besides the M word. When it says, I'm sorry, shooting. Mr. Khan says, as a part of your involvement in this case, did you review some materials? Yes. What did you review? Several hundred photographs. I was provided paper documentation, autopsy. I was provided access to physical evidence taken at the crime scene at various points. I dispatched a team of engineers to the crime scene to measure it up, or to the shooting scene to measure it up and get the physical dimensions of the room and the geometry of the room. I also went about getting some of the relevant evidence myself. Okay. Let's take those one by one. Did you also review x-rays in connection with this case? Yes, photographs of x-rays, and I received, I think, now 800 photographic images in connection with my work in this case. Wow. Do those images include photographs from the coroner's office as well as the crime scene? Yes. Do the autopsy reports that you reviewed also consist of amendments to those autopsies? Yes. And can you tell us, why did you dispatch some engineers to the crime scene for further measurements? Well, basically, I have a lot of photographic images of the shooting scene and pictures of the room, but obviously, I didn't get access to the room at the time of the crime. I'm coming along some years, or at the time of the shooting, I'm coming along some years later. And so I have to use geometry in the room that I can measure now if I have to infer dimensions of things that I don't know now. So it allows me to interpret the photographic evidence and gives me objects of a known scale or dimension if I need them. And did you receive information concerning objects in that room that assisted you in making the determination in forming opinions in this case? Yes. There was a huge amount of photographic evidence, and some of it with scales in it, which is always helpful. And then, of course, I was able to get the dimension of the room and the scene in the gross sense from what my people did. Can you tell us how long you have been working on this case and constructing and forming your opinions? Oh, a year, ballpark. Okay. And are you billing the district attorney's office for your time in this case? No, unfortunately. Aside from the fact that we don't have the money, can you tell us why you're not? Well, my normal billing rate is $600 an hour, and I suspect that's sort of like equal to or per day cap for a consultant or something. So I was not even, if I had the thought, it was not a very long lived one. Now, you said that in addition to the various reports and physical evidence that was provided to you, you also obtained some material of your your own as a part of your review of this case. What did you obtain? Well, based on the documentation I received and the evidence, one was a documentation on the firearms purchase that was involved in the shooting. And so I contacted Miss Georgia Nichols. She's general counsel for Mossberg Corporation, and she acquired for me a Mossberg shotgun here in a lower serial number than the weapon used in the shootings, that basically is a mechanical exemplar in every way, the same as those weapons that were purchased and used in the shootings. Are you referring to documents that were related to the purchase in San Diego on August the 18th of 1989? I couldn't do the date for you by memory, but yes, the weapons were purchased in San Diego from a sporting goods shop is my recollection, and I had the FFL purchase document, which required the weapon serial number. And what was your purpose in attempting to obtain such a weapon? Well, first of all, in a shooting, it really helps to have an exemplar weapon. But secondly, in my reconstruction, to the extent that characteristics of the weapon and the geometry of the shot pattern that it produced were or were usable in a reconstruction, I was going to use them. And once you obtain that weapon, did you also attempt to obtain a certain type of ammunition that would be helpful to you? Yes. Previous documentation provided me indicated that the Fiat ammunition was involved. That's the Italian manufacturer. So I bought a case of that for my ballistics testing. And what size did you use for that testing? When I had access to the physical evidence recovered at the scene, I was able to determine through my measurements that a number 4 buckshot, basically 24 caliber ball, was the buckshot size that was used in the shooting. So I acquired a case of number 4 buck. Uh-huh. There was some 8.5 birdshot as well. Did you conduct any experiments in regard to that 8.5 shot size birdshot? No, there were 2 shots with that, but none were where pattern of holes was such that replicating the pattern would have provided me any real information. So you didn't find it necessary to conduct experiments regarding the birdshot? No. Outside of knowing that it's 8.5. So it's 8.5 size birdshot. So you made a passing reference to normal sized buckshot and 24 caliber lead ball. What do you mean by that? Just that. That when you talk about buckshot and birdshot, those are different sizes. And so buckshot takes its name from being used for deer. Basically, it's a load in a 12 gauge shotgun that was a larger red lead ball, and you hear triple aught buck and double aught buck. You can buy buckshot down to 4, and even of those numbers, triple aught buck is the biggest, and that's my recollection is a 38 caliber lead ball. That's 308 thousandths in double aught buck is 32 thousandths, and all the way down to 4, which is 24 thousandths, 24 hundredths, 240 thousandths, and those are ones, and those other ones should have been 38 hundredths, 32 hundredths, down to 32. What? I didn't get any of that, and that was hard to read. And basically, you think of a 22 caliber bullet that's 22 hundredths of a diameter. That's that caliber in the diameter in calibers, if you will. They're fractional inches. A 38 caliber is 38 hundredths. It's 0.3 eighths of an inch in diameter. That's the normal diameter of the bullet. In the number 4 buck shot, each pellet is a normal 24 hundredths, 240 thousandths in diameter each pellet. And there are approximately 27 of them in a number 4 buckshot, remembering that the shot is loaded by weight. In other words, you get an ounce and a half of buck. So if you open 10 shells, you'll see 2 will have 26 pellets. What? Ms. Abramson says, I'm going to object to that answer as non-responsive and move to strike. The witness says, I'm sorry, I get carried away. So he's a nerd into this stuff, which is cool. That's fine, but you got to be precise and accurate and answer the questions. The court says the answer will stand. Ask your next question. Mr. Khan says, when you say that number 4 buck is similar to the 24 caliber lead ball, are you saying it's essentially the same size? It is a little 24 caliber mini ball. It is a round lead ball of 24 caliber, and there are a number of them in a shotgun. Okay, now, did you actually open some of these Fiachi number 4 buckshot to look inside and see how many of them are contained inside a shot? Yeah, we opened up a bunch. And what was the variation that you saw when you opened it up? Ms. Abramson says, I'm going to object unless the evidence is presented so we can all see it. Court says overruled. The witness says, we opened up 10 of these shells, and you'll see a couple with 26 pellets. Most of will have 27, one will have 28. I mean, basically, it falls around 27, which is the normal. Mr. Khan says, okay, and once you obtained the same type of shotgun that was used in this case, and you obtained the same type of ammunition that was used in this case, what did you do with that material? Conducted shooting tests at cardboard targets to see if there was a predictable spread in the shot pattern that would allow me distances. And what were your findings as a result of those experiments? Basically, the spread shot to shot. Your Honor, again, I would object without the actual patterns being present. The witness says, okay. The court says, wait, wait, wait. There is no reason to require that they actually be presented, but if you intend to do that, you may do that as well. But the objection's overruled. Mr. Khan says, perhaps later we will get to that. For the moment, can you just tell us what were your findings in this regard? Basically, the variation of shot to shot and pattern size was such that it was not a reliable indicator of distance or something that could assist me materially in establishing the distance from which various shots were fired. And what did you mean when you said that it was not a reliable indicator of distance? Well, just that. In other words, if you shoot from 6 feet or 12 feet and your shot formed a certain pattern, if you shot 12 shots or 5 shots with the same gun and the same ammo, you'd like to have sort of the same sort of pattern. If the patterns are smaller and larger from shot to shot, then you've got a lot of variation. That's been reported in the literature for shotguns for a long time. But I had not seen shot to shot at the same ammo in the same gun reported before, so that's why I had to do those experiments myself. The variation, even in the same weapon with the same ammo, shot to shot, is significant enough that I got targets here. I can show you what it is. It is enough to make use of the information in a reconstruction problematical at best. It's enough to make use of that information in a reconstruction problematical at best. Okay. Now, do shotguns sometimes have some sort of variable mechanism called a choke? Yes. And what is a choke? Well, a choke is a construction of the bore trying to bring the shotgun column. This guy is not a shotgun expert. He's not an ammo expert. He's not a ballistics expert. So why is he? They're using him as a gun expert. This is crazy. He says, well, the choke is a construction of the bore trying to bring the shotgun column of shot in closer proximity, leaving the barrel so that it will stay tighter downrange to the barrel. And we talk about in our society basically a cylinder bore, and there's no choke. We typically talk about a modifier cylinder, that's a quarter choke. We basically make these improved, modified, all the way up to the full choke. And a full choke is about 40 thousandths construction on the barrel, and it goes in about 4 steps. quarter half, and 3/4. I'm thinking of the modified, improved, modified, and finally a choke. What? This guy just likes to hear himself talk about nerdy, specific, big words in these topics that, not everybody knows about, like ballistics, and he's not even here for that, for guns. And he just goes on a roll, man. And I don't know, understand anything he just said to explain what a choke is. That was just like a weird rant. And he's still not done. He goes on to say, and what those do is establish varying degrees of constriction on the shot group leaving, of course. The price you pay for that is you damage the shot a little bit with a choke. So you rough up the shot more, but they're a little tighter group. Or they are a tighter group. Does that mean when a person who purchases a shotgun, the person buying the shotgun has a way the shooter himself can adjust the shotgun to control the spray of pellets that will come out of the shotgun? On a more expensive shotgun, yes, you buy a very nice Italian-made shotgun, and the front will actually you'll get cylinders that screw in that will change the choke, how much the barrel brings the shot group together. On a less expensive shotgun, you cannot control choke. It's built into the barrel. Even a cylinder bore, which is normally a straight cylinder, has an inner normal choke just to improve the stability of the shot group a little bit. In less expensive shotguns, the choke is built in the barrel, and as you get to the more expensive, you can change the choke. You don't have to explain so much, buddy. Now, for the shotgun that you obtained in this case, which you said was similar to the shotgun that you purchased in regard to the particular incident, is there any adjustable mechanism on the gun? No. So, in other words, if you put in a shotgun shell and you squeeze the trigger, you have no control over the spray pattern. Is that correct? You can't vary it. The way the gun is made is the pattern that you're going to get. This weapon is made with cylinder bore. There is no normal choke. Mr. Khan says, did the court wish to recess at this time? The court says, okay, we'll be in recess until tomorrow. We won't be in session in the morning. We'll resume at 1:30. We'd asked you to get here a little before 1:30 so we can start promptly at 1:30. See you back here tomorrow, he says to the jury. And looks like we've got a little bit of argument here. So, yeah, so that is the end of this day, which is the 8th, but they have a little bit more argument. So the jury, I believe they left. Yeah, the jury has exited. The following proceedings were held outside the jury's presence. Ms. Abramson says, Your Honor, could the court stay out and the witness as well? Thank you. The court says, okay. Ms. Abramson says, I just want to make a discovery request, which is that Dr. McCarthy bring these rounds that he opened up where he says the numbers are different, assuming he presents them in a way that can't be tampered with. The court says, or if he has them. Ms. Amerson says, or if he has them. Secondly, I would ask, I know he brought a case of his ammunition and he did bring it to the court in the 801 hearing, and I'd like to make sure that he brings some of this uh, as well. Do you have any? The witness says, I have some shells from it. The stuff I had at the preliminary hearing, I have here. It wasn't a preliminary hearing, it was just some hearing. Probably motions hearing or something. Or no, the 801 hearing, she said. Um, he says, I have here, I didn't bring any live ammo. They really get fussy downstairs. Ms. Abramson says, I know they do. Just let me see what you've brought, and then I'll let you know if it's adequate. Otherwise, what we do with live ammo right now, since the first trial, when we learned our lesson, is we give it to the sheriffs and they bring it up. The witness says, I have one of these, which is a box, and I have the epoxy-filled exemplars. Miss Abramson says, why don't you bring, Your Honor, I do need to see an unopened, undestroyed round or two if the witness brings it and turns it over to the sheriff's department downstairs. The court says make arrangements ahead of time to do that before any live ammo is used by counsel for any purpose. You discuss it with me. Ms. Abramson says, yes, Your Honor. The court says, and no live ammo up at the witness stand at the same time if there's any as the weapon. Ms. Amerson says, my understanding is what needs to be done is the witness brings the ammunition. The court says, I don't want to go into detail. Ms. Amerson says, I will. The court says, that's all up to your making arrangements with the sheriffs. We'll be in recess. Mr. Khan says, one additional thing. I just learned this afternoon that Mr. McCarthy, who has been here all this week, with the hope that perhaps we might have finished Dr. Lawrence early, and he was prepared to testify all this week. I've just learned that Mr. McCarthy does have a scheduling conflict for Monday, and I was wondering perhaps if the court might be able to accommodate him. I understand that he has a presentation to be made in San Francisco on Monday. Ms. Abramson says, this is your last witness? Mr. Khan says, I think we're going to call Detective Zoller for a few questions, some odds and ends, but I'm sure that won't take much time. And they do call Zoller back a couple times. Ms. Abramson says, we have some things we can ask Detective Zoller as part of our case, which we would be willing to do. The court says, if you have some things you can do out of order, that will be helpful. Ms. Abramson says, with Detective Zoller, the court says, if you can come up with enough to justify the jury being here, it would be. Ms. Amerson says, I don't know if it's enough for the jury being here for the whole day. The court says, perhaps there are some other matters that counsel can do with the jury here without Dr. McCarthy, and we can resolve it tomorrow. Ms. Amerson says, the only problem is if that means Dr. McCarthy doesn't come back until Tuesday, I have got witnesses flying in next week with the expectation they're going to get on, but I think it will work. He's going to be here on Tuesday. I have Dr. Fackler on Wednesday, Dr. Wecht on Thursday or Friday. I have those 3 days for Fackler or Wecht. Okay, I guess that will work. The court says, but if you have other matters that you can utilize Monday with the jury, it would be of help. Let's see how we can work it out so we can accommodate the witness's schedule. All right, we'll be in recess until tomorrow. And that's where I'm going to end this stream. I will be back tomorrow. I'm going to pre-record it because I got, whatchamacallit, I got an infusion tomorrow for my medical stuff that I got going on. So I will pre-record tomorrow's episode. We will continue on Dr. McCarthy's testimony. I believe, I don't know, I had it up. So it's going to be Dr. McCarthy. Zoller's going to be recalled. McCarthy's coming back and then Zoller again. And then that's the end of the case, the state's case. And then we will get started with the defense. So we are almost there with finishing up the state's case. And I'm sure it'll get much more interesting. I think this stuff is boring and I think it's all a bunch of lies. um, or a lot of the witnesses in this case for the state, it seems, especially Dr. Lawrence and Dr. McCarthy right now are kind of paid experts, perhaps. I don't know. At least kind of the way I'm leaning right now. What do you guys think about that? Paid witnesses, paid experts, are they just here getting their paycheck and testifying however the state wants them to? Or I think Dr. Lawrence did actually a good job in like sticking to his morals and saying, I don't want anything to do with those diagrams. And also my stupid doll that I made is incorrect. So at least he admitted to things, but he didn't do it until he was cross-examined. So that is part of the issue too. You represent yourself one way when the state has the direct examination with you, and then once certain questions get asked, a different picture starts to unravel, and that's kind of what I'm thinking is happening with these witnesses. Let me know your thoughts below in the comments below, and hit the like button, subscribe, and all those YouTube things, and I will see you guys in the next episode. Take care. Bye now. Whoopsies.